appeal in the matter of Dwyer and Fredbar and Arnoild.
Yes.
Lords, good morning. I appear with Mr Strelitz on behalf of the appellant.
Yeah.
I've known friends Mr Grant and Mr Chung appear for the respondents. Lords, as you will know, this appeal concerns the rejection by a trial judge, the trial judge of post-termination restrictions contained within a franchise agreement. The appeal gives rise to some potentially important points, and I'm going to, if I may, trespass on your time for a few moments, just to assist, I hope, the court with a little bit of background on the issues which apply in franchising. So, the context of franchise agreements will no doubt, in some respects, be familiar to the court, so I won't take long over this, but forgive me if I just take a few minutes. The foundation, a franchise network is established in order to create an international or national or regional brand with significant coverage of the market, which is then going to be serviced typically by a network consisting of franchisees and possibly some what are called corporate stores, which are the equivalent of territorial franchisees but actually owned by the franchisor. Each franchisee constitutes a separate, independent business, and the franchise network with which this case is concerned was not alone in promoting the possibility that a new franchise, a new franchisee, or individuals behind the franchisee could become very significant businesses, and not just in one territory, but in more than one. So a franchisor will not typically start to market franchises until there is goodwill in the name and the business model. Indeed, it's not considered good practice to do so by the BFA, and this franchisor was a BFA member. I will come on to look at authority in due course, and one of those authorities is of the then Mr Justice Neuberger in a case called Dynarod.
Yes.
And when we come to those, and I very rarely do this, but I'm actually going to go through the authorities with your indulgence today in chronological order, because it's very interesting to see how it builds up through Nordenfelt onwards to the 1990s and beyond, where we actually get now a relatively substantial body of authority on the application of restrictive trade to franchise networks. It's an interesting progression.
But we have to look at the circumstances of the particular franchisor and franchisee, don't we?
Of course we do, but the context in which we look at it.
Whatever the position notionally might be as between your client and other franchisees who are a good deal more successful than this one, we're actually concerned with the reasonableness of this restrictive covenant in relation to this franchisee.
Yes, that's absolutely correct, and I'm not suggesting anything other than that for the moment. But when we come on to look at Mr Justice Neuberger's authorities...
Well, what I'm really trying to say, Mr Jones, is that I think there's I appreciate what the authorities say, but there's a degree of flexibility in the approach that the court should adopt.
Of course.
Even in the case of a franchisor-franchisee relationship, which may be closer to employer-employee than it is to seller and purchaser.
Well, Lord, I'm going to deal with that, if I may, because one of the issues in the case is where it is on that scale.
Yes.
I'm not speaking for myself entirely convinced that it's much of a helpful debate in one way, because
you may very well be right about that.
Because and the reason I'm starting with where I'm starting is precisely to set the foundation for that debate, Lord, if I may, because this is quintessentially a commercial arrangement. I'm going to come on and deal with what the judge said about the success of that commercial arrangement and how it affected Mr Bartlett. But we start with the proposition that this is quintessentially commercial, and we're going to look at some numbers which, on the face of it, the judge accepted, which shows that this was potentially a highly successful operation for Mr Bartlett to enter. So it's what the franchisor is created and is providing, which is the bedrock of the commercial relationship which the franchisee elects to enter. That's the important part. So there's no doubt at all that if your lordships are asking yourself not the sliding scale question between vendor, purchaser and employment, but asking yourself the question, is this a commercial arrangement intended to create commercial profit? Not only annual profit, but capital profit, because it becomes a saleable capital business as well. Then at that point, in a sense, I don't wish to sound flippant, but one could lose interest in the other debate as to where you stand on the sliding scale between employment and vendor purchaser, because one is just looking at it as a commercial venture. So what does the franchisor typically do, and what did this franchisor do? Because what it did here was entirely typical. It will create the business model. It will create the systems necessary to support that model. It will create a detailed manual which will tell the franchisee how he manages every conceivable part of the business to his benefit. It will provide training at the start. It will provide training and further support during the franchise. And I'm going to come on in due course to just run you through. I won't do it now, but this is by way of introduction. I will come on and walk you through precisely what this franchise agreement did provide to Mr. Bartlett. So everything there are subsets essentially of the business model that has created the goodwill. So whether we're having a debate about vendor purchaser and so on and so forth, the one thing we do know, which is a constant in relation to vendor purchaser restrictions and franchise restrictions, is that the starting point is the goodwill to be protected. So the franchisor creates the network, and the success of the network depends on the success of all the elements I've just gone through: the business model, the brand, and the quality of performance of all franchisees. And there is a policing requirement for a franchisor because franchisees expect franchisors to maintain the value of the franchisee's territory and franchise business by ensuring that other franchisees enhance and do not devalue that brand. And while it is typical to find what I would call generational iterations of franchise agreements in one network, simply because of the function of when they're entered into, generally they will always form into having a common aim. That's maintenance of standards, maintenance of the brand, and appropriate control of competition. And while I understand entirely that this case is looking at the relationship between the claimant and the defendants, and it's right that it does and should. At the end of the day, if, for example, as your lordships may posit, there are two contiguous or near contiguous franchisees, then the appropriate protection of the franchisor's goodwill includes the money that will go to the franchisor via not only the franchisee with his territory, but all other franchisees. Hence the interdependent nature of a franchise network. So restrictions are there And
evidence as to where the next nearest franchise was?
at the time, I can't answer that. Mr. Strelitz may know. But Lord, I'm talking in general here. So, for example, I don't think it would be an answer to the point that I've just put if at the time there wasn't another continuous franchisee, because we're looking at a 10-year agreement, and the likelihood is there will be during the course.
Understood. That point's understood. But here we are 4 years on from when the franchise was entered into. And I just wondered if there was any evidence as to...
Well, I'm not aware of any evidence. I may take instructions, may be able to answer it on instructions if your lordships will find that helpful. But unless I've missed it, I didn't do the trial, so
No, I understand
my
that.
knowledge of the facts are derivative. But unless I've missed it, I can't.
I was just wondering whether there was a franchise in Swansea, for example, or a franchise in Newport.
I will do my best to find.
Or Bristol.
I will do my best to find out
places that are close by.
Yeah, I will do my best to find out the answers to that.
Because if in fact the reality is that there is nowhere else in, as it were, in South Wales, then the point you just made has less full. I mean, I follow your point that you might be looking at the future, but if you know, the fact of the matter is that you're not, to the same extent, protecting the brand in South Wales if you've only got one franchisee in South Wales.
Well, Lord, I'm going to come on and deal with that because I've got a little footnote to deal with that at the moment.
Yeah, sure.
Later on. But let me just mark it for your lordship now.
No, okay.
And that is the goodwill, the protection necessary for the goodwill of what I'm going to call a fledgling business. So let's suppose, as I think is the position here, in other parts of the country, there were significant concentrations of franchisees doing extremely well with seven-figure businesses, and I'll take you to the part of the judgment which makes that clear in a moment.
Yeah.
So let's suppose, and I'm just having a discussion about this for the moment. I'm not anchoring this into any particular fact. Suppose it's then decided that the next region that the franchisor will seek to exploit for the franchise network would be Wales or South Wales. You've got to start somewhere. The plan would be a franchise network. Therefore, the interdependence of which I speak is no stronger because we happen to be looking at the first one. Because this is a 10-year deal with provisions for renewal. And it would be, in my experience, I'm not trying to give evidence, but in my experience, it would be extremely unlikely that anyone would want to launch a brand new single territory franchise in an entirely new area, unconnected with any other area, with no potential or plans for expansion. That wouldn't make any sense at all for the franchise model. So all franchisees will thus be expect to be the subject of restrictions because every franchisee will expect every other franchisee to be subject to restrictions. Precisely so that on termination of a franchise agreement, the franchisor has the ability to recruit a replacement and install that replacement and get that replacement going without inappropriate competition. That inappropriate competition, which we know, as we all know how the world works in this case and in many others, and indeed it worked in this case, it involves the exploitation of existing customers, existing reputation in the area, and so on and so forth. So these expectations of the network of franchisees, as I've said, form part of the goodwill of the franchisor as its ability to sell franchises and recruit a franchisee is a function of the success built on the brand as a whole. And one of the things I'm going to come back to, but let me leave you with a footnote thought on this point, is how does the trial judge's approach to this work? So, for example, he's posited the proposition in one of the subparagraphs of paragraph 305 that it could never be a fair and reasonable protection for a restriction not to have a clause in it saying it could be set aside by agreement or disapplied, as I think the expression he used, with consent, such consent not to be unreasonably withheld. Let me just see how that cannot conceivably work. It's a useful part of my introduction to put this in. A franchisee, the franchise agreement is terminated for whatever reason. The franchisee then says, not because he's operating as Mr Bartlett was behind the franchisor's back, secretly, but he would do it openly and say, I know I've got this restriction, it hasn't worked out with you, but I do want to make a living and I want to start having competition, please. At that point, the posit of the trial judge is that there is a debate to be had between the franchisor and the franchisee as to whether the franchisor should or should not reasonably or unreasonably withhold consent for that competition to occur. But what he desperately needs to do at that point is identify a new franchisee, recruit them, train them, and get them up to speed to replace the outgoing franchisee. So when, one might forensically ask, when is this idea of some reasonable or unreasonable withholding of consent to be tackled? If it's tackled immediately, the franchisor won't have a clue at that point how long it's going to take him to replace, and with what quality of replacement and so on and so forth. If he waits, of course, the whole purpose of the clause that the trial judge thought was necessary goes and is too late. So there's practicality here as well as principle. Now, every franchisee goes into a franchise in the hopes of creating a self-standing business, and that's the most important part. And if circumstances arise, that's a business that may be sold for capital profit, not just annual revenue. And it therefore follows that if somebody like Mr Bartlett wished to commence a drainage business, he'd have to create for himself from scratch the model, the name, the brand, the business system, the training, and so on and so forth, and the pricing, and all the rest of it. What he gets is the ready-made ability to start a business which has been created in effect for him in the anticipation and hope that he will not only acquire annual revenue, but capital growth as well. Now, the capital value of a franchisee's business will also depend on restrictions for precisely the same reason. So it's clear that while certain territorial restrictions are permitted, so I'm venturing, I do so with some trepidation in light of the composition of this court, but I'm dipping my toe into some competition issues here. While certain territorial restrictions are permitted, one can find sole or even exclusive franchisees. There's a difference between those, of course. It's often possible to work outside one's franchise territory. And while active marketing out of area may be restricted, passive marketing cannot be restricted. So every franchisee is therefore interested in the franchisor ensuring that all other local franchisees are similarly restricted from post-termination competition, because the franchisee who's left was not restricted to the territory which was allotted to them. And we'll come on to see, your lordships will have seen in paragraph 305 itself, the reference, and when you looked at clause 18, which I'm sure you have in the franchise agreement, the reference to what I'm going to call the buffer zone outside the exclusive marketing territory. So that's the second of the two sub-paragraphs. Can I just leave your lordships with the reference? I don't think I have to take you to it. I have mentioned here the prospect of capital value and sale, and this was a saleable franchise. There are obviously certain conditions attached to it, but it is a saleable franchise, and the reference to there is clause 16, page 256 of the supplemental bundle, and schedule 6, page 302 of the supplemental bundle. Lord, I don't think the precise terms of it need to be gone to, because the principle is absolutely spot on. So a franchise is quintessentially a commercial, business-to-business relationship in which the franchisor agrees to impart the system, the model, the training, the license or lease, and the goodwill, if that's what the current formula is to call it, pursuant to Call Quick and Dynaroll, and the machinery to continue to build the brand and the network with continued national and regional marketing, which is also a function of the franchisor. In return for that, the franchisee agrees to pay normally a turnover-based commission and abide by the performance standards and restrictions which apply across the network for the protection of the franchisor and everybody else. So with that in mind, it's then necessary to consider the type of restrictions which the law permits and how it goes about assessing them. In short order, and I'm not going to try and pretend that I should summarise just over 120, just under 120 years of authority, but in short order, a restraint of trade clause is valid and enforceable if the covenantee has something which is entitled to be protected. Question 1. Question 2, the restriction affords the covenantee no more than reasonable protection for that. But I'll show you in due course where the foundation for those 2 points is to be found. Essentially, the process of considering a contract and the reasonableness of any restriction in it must look at the time at which the contract is entered into. And I'll show you authority, which underlines that point. And I would venture to submit, though I'm always find myself out of my depth if I venture into analogies from other parts of the law, but I venture to submit that what the court is involved in here isn't very different from the construction of any contract. So when one looks at clause 18, one is not only looking at the fact that it's a restraint of trade clause, one is also looking at how to construe it. Now the construction...
Sorry, I don't quite understand that.
Lord, I'm sorry.
It's well established, is it not, that step 1 is to construe the clause,
Yes.
and you do that according to entirely conventional principles.
Yes.
Step 2, once you've construed the clause, is you then consider its reasonableness. But those are 2 distinct exercises.
Oh yes, they're absolutely distinct exercises, and I wasn't pretending that they weren't. But one is answering both of those exercises in relation to the same point in time, namely when the contract is entered into.
To be sure.
So, Lord, that's the only point I was making, and if I spoke ineptly and led you to think otherwise, that was not my intention at all. So, Lord, the point, and I think your Lordship's needs no further submission on it, is that the point in time at which the exercise that the trial judge was entered into needs to be carried out is October, for our purposes, October 2018.
But I take it you wouldn't dispute that construing the contract at that point in time and considering its reasonableness at that point in time, you have to take into account the expected duration of the contract. So here, 10 years.
Yes. Yes. You take into account everything. You would look at the duration of the contract. You would look at the although we're going to come on and see that the consideration bestowed is not a function of the restraint exercise at all, it is, of course, a proper function of this exercise to look at what the parties are entering into and what their mutual obligations and rights are going to be. So that's why I've started, there is a distinction between those 2, and that's why I've started with the franchise structure. Because what we will see is all the features of a typical franchise were, I'm going to say bestowed upon. That looks as if I'm looking at it from a consideration point of view, and I'm not. Those were all features which we find in this franchise and this franchise agreement, which the parties, and I'll do it in contract terms if I may, and I hope Lordship finds this correct, that the parties contemplated when they entered into the agreement. So before turning to the legal framework, can I pick up please some key aspects of the dispute? And I'm only going to do this by reference to the judgment. So the judgment will be the core of how I'm going to do this. There will be 1 or 2 references to the evidence where it looks to me as if that evidence has either been acknowledged or not disapproved of in the judgment. So one can take it into account as part of the background. So But what I'm going to do, please, is just start at the very last page of the judgment, and I'm going to go to the very first page of the judgment. So the very last page of the judgment tells your lordships what it was that was being debated during the course of this trial, which is, we respectfully submit, to some extent helpful. So we can see paragraph 310, and so subparagraphs little a and little b were allegations by the franchisee of misrepresentation and undue influence. They failed. Subparagraphs C and D, allegations that the claimant was in breach of certain provisions of the contract which had no effect because the contract was affirmed. Subparagraph E, the claimant's case was that the defendants were in repudiatory breach, and C accepted that, and that succeeded. Subparagraph F, C was successful in enforcing certain provisions in the contract, such as, significantly, the transfer of the telephone number from the franchisee, which was being used for his competitive business. Subparagraph G, C successfully proved that D had traded in competition before termination and had a right to damages, though the damages weren't part of the trial. And H, which is where we come in, the post-termination restraints. So one of the reasons I've taken you to that is because we fear that a lot of what I might call the extraneous matters have influenced the trial judge's decision. Whether we're right about that, and I don't mean that in any sense disrespectfully to the ICC judge at all, but whether that's happened or not, we matter for your lordships. But it's, I think, useful just to see the context in which he finally came on at the end of his judgment to consider the question of restraint. And it's fairly clear where his instinct was as to where he wanted that debate to end up, I think. And I'm going to, I hope, make good that in due course. So can I now go back to the first couple of pages of this judgment? So this is, if your lordships will forgive me, I'm going to use bundle numbers unless you invite me to do otherwise. So this is tab 5,
paragraph numbers, actually, Mr. Jones.
Paragraph numbers as well.
If only because the copy in the bundle is such small type. Speaking for myself, I printed it out from Bailey. Not that we're allowed to use Bailey anymore, but I printed it out from Bailey and therefore got a slightly easier to read version.
So, Lord, then I will try and give all the references in one go. So I'm looking at paragraphs 1 and 3, and that's page 36 and 37. And what we see from that is that Dwyer is the UK franchisor of Drain Doctor, plumbing and drain repair, and we see from paragraph 3 that it had 30 franchisees over 60 territories. Then paragraph 4 on the page 37, Fredbar was formed in September 2018. It was the company of Mr Bartlett, who had no previous experience of plumbing or drainage. Back to paragraph 1 on page 36, the parties entered into a franchise agreement on the 4th of October 2018. Lord, for the purposes of these submissions, I'm not drawing a distinction between Fredbar, the franchisee, and Mr Bartlett, the guarantor. I don't think it's relevant for the purposes of your lordship's quest. Then can we look, please, page 38 of the bundle, paragraph 8, for Lord the Chancellor.
Yeah.
What it tells us is that the franchise agreement was an exclusive franchise agreement for 10 years with provision for renewal. It contained restrictions including active solicitation outside territory, and I've already drawn the distinction between active and passive in my structured opening. Those are all fairly standard form provisions in franchising. Some franchise agreements 5 years, some for 10 years, but other than that, there is nothing here which is anything other than, using today's expression, plain vanilla. So could we then go to paragraph 10, please, page 38 still. C was to provide initial training and advice and could assist with further with establishment and operation of the business. Could we then go through, please, to page 45 for us, paragraph 46. We know that the claimant made available a qualified franchise professional to assist Mr Bartlett. Now that is a status, your lordships don't know, it is a status granted by the British Franchise Association on suitably qualified people, and those people could then be made available. Drain Doctor was a member of the BFA, and they made a suitably qualified franchise professional available. So that would be at their expense, as I understand it, but not employed by them, engaged by them in any way, completely independent. If we then please go to page 50, paragraphs 75 to 76. I said to your lordships a few moments ago that I will take you to a passage in the judgment which appears to accept, I think without question, some of the numbers involved in other parts of the network. So what we see in 75 and 76, I'm not going to go through them in individuals, that there were franchisees doing very well indeed with 7-figure businesses. And that is part of the background to the parties' mutual intentions when they entered into this commercial relationship. If we go over the page, on our version of it, but paragraphs 83 and 84, we know that this...
Sorry, just so as we're clear, as I understand it, the point the judge is making in paragraph 76 is that while there were a couple of big franchisees that were doing well, the overall picture was, shall we say, more mixed.
Yes, but it would inevitably be, I would imagine. Some businesses will do better than others, some regions will do better than others, some business people will do better than others, and so on and so forth. But what, whether one goes into a business relationship hoping for the best result or for a median result, there is still here, whichever way you read this, a result of success that was within the contemplation of the parties. So I'm not saying that my submissions turn in any way, shape or form on saying that what their contemplation was that one or two half dozen high numbers here, the highest of those numbers. I'm not saying that, but it does go to provide the background to the parties' discussions and what their contemplation would have been. So we know, I then moved on paragraph 18.
The context was, as is clear from 76, that whilst there were a handful of franchises which were making over £1 million a year turnover, the vast majority of them were on a much more mundane level, and therefore the picture that was painted was a very different one from the one set out in the advertisements. Now the judge found that Mr Bartlett hadn't in fact relied upon the advertisements in entering into the contract. What he was dealing with here was the question of fact as to whether the reality on the ground was as set out in the advertisements.
Oh, that I don't dissent from.
So in a sense, that's you're trying to use this material as the basis for saying, oh, look how wonderful this all was.
No, Lord,
slightly,
Lord, the one thing, Lord, I'm sorry, I spoke over you, I didn't mean to, I'm so sorry.
No. But I think that was the impression you were trying to create, that franchises were doing very well indeed, but there's only a handful of them that were doing very well indeed.
Absolutely not. Again, if I've been inept in that, my purpose is to describe, and I've taken you to both of those paragraphs quite openly, is to describe the highest and the median levels of commercial success, which would have formed part of the commercial contemplation of these parties. Of that, there can be no doubt. I do appreciate that the judge was probably looking at that material, at that part of his judgment, for a different purpose. And one of the reasons I took you to paragraph 310 is precisely so that your lordships had in mind the different strands of argument and submission that the judge was dealing with. In many respects, quite a complicated case, but there it is. I sought to derive.
That's the point of my lord's question. which is they're setting out data from the claimant's records. This was not information that was known to Mr Bartlett at the time of contracting.
Well, that may be right because of the point about non-reliance. But whether it was in...
No, that's a different point, because that's the question of whether he relied upon the advertising puff, and the finding was not. But you're trying to submit, as I understand it, that the financial figures we find in 75 and 76 are part of the factual matrix. And that's what I'm questioning, because the financial figures come from the claimant's records, as is stated in 75.
Yes.
There is no finding that those financial figures were known to Mr Bartlett at the time of contracting, and it's inherently unlikely, isn't it?
Lord, as figures from the franchisor's records, I think that's right. Reliance is different from what he read, and he will have read the advertisement.
Indeed.
So, Lord, I was going no further than that, and it's assumed a significance in your Lordship's mind, which I hadn't intended to clothe it with, and I hope that that's a sufficient answer. So I then wanted to move to paragraphs 83 and 84, page 51. We know that Mr Bartlett spoke to other franchisees before signing up. So he knew he was joining a network. It's not as if he didn't understand that fact, that part of the factual matrix. He didn't understand that's what he was signing up for. And he appreciated, we respectfully submit, the benefits he would obtain from being a franchisee in an established network, including the exclusivity of territory that he would be purchasing. And 83 and 84 are relevant to that purpose. If we then move on, please, just on the same page for us, 85 and 86, we know, and this is an important part of the judge's assessment and Learned Friend's response, is that he provided a self-assessment form disclosing his assets. Now, if I forgive myself a footnote here, it's extremely difficult in my submission to see the relevance of that to any issue in respect of restraint of trade, but I'll come back and hopefully make that good in due course. Could we then go to paragraph 94, page 53? What we then hear, and I'm anchoring what I'm saying in the judgment as closely as I may, Mr Bartlett was prepared to proceed based on projections derived from average franchisee data. That was his decision. The judge accepted in this paragraph and made it crystal clear in paragraph 293, we'll pass by that in a moment, that this was akin to a commercial vendor-purchaser relationship and did not give rise to the same treatment of clauses in employment contracts. So that's the basis upon which, at least on the face of it, the judge proceeded. If we then move to page 54, paragraph 99, it said here that he considered those projections carefully. 2 pages on for us to 56, paragraph 107. He was sent a copy of the franchise agreement in standard form. And it said that he could have studied it, but didn't. That's repeated as well in 128C on page 60. We then go to paragraph 108, which is the foot of that page. So he attended an induction day. This was before he signed up. Now, I've also taken you to this passage because it is specifically referred to in paragraph 305. So it's right that you have this in mind. because this is a mix of assessment by one person in Drain Doctor of him. When I say
He wasn't
a mix,
just one person, he was the managing director, wasn't he?
Monsieur Jean, yeah, I think he was Pierre Jean. Yes.
So not just a person, he was the head of the company.
Yes, he was certainly speaking in relation to this recruitment. So, Lord, what's important about this, and I want to draw it to your attention particularly, is that it is an assessment, but which is a mix of an assessment before signature and after. So, relations with customers is a part of that assessment, which, on the face of it, ought not to be part of the consideration of what we're looking at on the day of the contract.
I don't understand that submission,
don't
because
understand
that's
that either.
squarely a finding in relation to the 26th or 27th September.
No, Lord,
Mr Jones and his evidence in chief stated having met Mr Bartlett before and at that event, and then the quotation about what he knew.
yes, Lord's absolutely right. So I said that's why it's a mix of an assessment before and afterwards, because he goes on to
Where
say
does he refer to afterwards?
he
That's
had
before and
difficulty in building relationships, including subsequently with customers. That has to be afterwards. Lord, that's the passage to which I'm referring.
I see. Thank you.
Lord, I'm guilty maybe of going too quickly. I'm not explaining what I'm taking you to these paragraphs for as fully as I might, but that was the purpose of it. It seems to me it has to be.
Well, he added on, I mean, I think my lord's right, that what Mr Jeans, or Jean, how he pronounced his surname, is saying is this was the assessment I made of Mr Bartlett at the time, before and at this event, and it was borne out by his subsequent ability to deal with customers.
Correct.
And that's essentially what he said.
Correct. I don't dissent from that at all.
And the judge says, well, in those circumstances, you expected him to have said, well, this man's not really suitable to be a franchisee. But there we are.
Lord, what I'm going to be asking you to accept in due course is that may have been relevant to all sorts of parts of the case. It's undoubtedly not relevant to restraint of trade provision. That assessment has no part to play in considering the reasonableness of this restraint. I'll come back and make that good, or attempt to make that good. I shan't promise to do it, but I will do my best. The reason I've taken you to this is that it figures in paragraph 305. It's an important paragraph. It has the mix that I respectfully submitted it does, but it's also leads the judge into error when he, in due course, renders his judgment in paragraph 305. Paragraph, please now 203. So I'm going on to page 73, quite a long way further into the judgment.
Well, the context in 305 is the judge is looking at the issue of reasonableness as between the parties in view of the effect of the restraint of trade on Mr Bartlett's financial and domestic situation. Part of which is by reference to the fact that the claimants knew that they were putting it colloquially, taking a bit of a chance with this chap because of Mr Jean's assessment of him. Hence, the judge says, in that context of knowledge, the claimant through Mr Jeans had formed the opinion failure was foreseeable. The judge isn't saying that this assessment is as it were relevant per se. It's actually part of the claimant's knowledge of the defendant's precarious financial position.
Yes, and my blunt answer to that is that this assessment in this paragraph 108 and his precarious financial situation have nothing whatever to do with the reasonableness of the restraint. And that's the error the judge fell into. And going to have to make that good. But
Indeed, because it seems a little counterintuitive to say that reasonableness has nothing to do with how precarious the franchisee is.
because the franchisee has made this is a commercial relationship that the franchisee has investigated. We will see that he's gone off and spoken to business manager at NatWest Bank about it. He studied the projections, formed his own view. He's gone into it, not gone into it in order to be a failure, he's gone into it in order to be a success. Whatever assessment the franchisor would have made of him, and I can't dissent from this paragraph. There's nothing I can do about the words in paragraph 108, I haven't tried to hide from them. But the franchisor wouldn't have gone into this on the basis of wanting him to fail, they would have gone into it on the basis of wanting him to succeed. And indeed he could have done.
Well, I'm not sure
So-
about that, because I think what the judge is finding is that the franchise, both at 108 and 305B, is that the franchisor was aware that this franchisee was likely to fail and was going into it on the basis that, as he put it, everybody deserves a chance.
But not bound to fail. So the problem we've got here is, and I'm going to come and address these in more detail in due course. The problem that the judge has set up is that this is an assessment of whether a restraint is reasonable because of the personal characteristics of the covenantor. And I think I can safely say to your lordships that if you, on this appeal, stand by that judgment, that I think will be a first. Because that is not the basis upon which, over the last 100 years, restraintive trade clauses have been assessed. Because if one stands back from it, what the trial judge has set up here is the prospect that the franchise agreement had in it an unreasonable restraint clause. Because everyone contemplated the franchisee being so bad as never to be able to offer any competition at all. And that cannot be right. That the parties here entered a commercial agreement, and whatever they thought of each other, whatever Mr Bartlett thought of the projections, whether some of them were good or bad, what other franchisees he spoke to were helping him or not helping him, he made a choice to go into a commercial agreement. The franchisor made a choice to go into a commercial agreement, and for the purposes of it succeeding, not for the purposes of it failing. And
Do you submit that equality of bargaining power or inequality of bargaining power is irrelevant to assessment of the reasonableness of the
yes, I do.
restrictive covenant?
I do. And I do because it's the wrong question. The question the court has to answer is, what is it that the franchisor has that justifies protection? That's my question one. And what is the reasonable level of restriction which is appropriate to protect that asset, or whatever that
That's not
is.
what the cases say. What the cases say is with the reasonableness of the restrictive covenant as between the parties.
Yes, and I'm going.
And a lot of the cases also say, going back to Nordenfeld, and as regards the public, which is a different issue, which is the anti-competitive.
That's the
issue.
third issue. That's the third issue with Lord. I spoke over you, great end. I'm so
But I
sorry.
mean, it's looking at the position as between the parties, not simply looking at. Of course, an element of that is the issue of what is required to protect the franchisor. But I must say, speaking for myself, I find your submission that the position of the franchisee and issues of inequality of bargaining power are irrelevant to these questions. I find a surprising one. But if you can make that good on the authorities, so be it.
I think I can. Let me just explore that with you for a moment. Let's supposing there are two parties with equal bargaining power or unequal bargaining power, and the court concludes that the restriction is unreasonable. then it's unreasonable if it goes further than is necessary or adequate to protect that which the covenantee owns, which is entitled to protection. If we flip that question and ask ourselves whether in a standard form contract where there may be no ability to negotiate in reality, it makes no difference to the objective assessment of the interest in the franchisor, which is deserving of protection, and what it is that the protection should then, what should the protection then afford. Let's stand back, if we may, for a moment. We're going to come on to look at this, the law, but for the moment, I'm going to show you dicta which make tolerably clear that it is in relation to the interests of the parties, but the interests of the covenantor is the same as the interests of the covenantee because of what the covenantor is acquiring. So I do stand by that proposition, and in terms of equality of arms, it makes no difference. And the reason it makes no difference is because one cannot have, conceptually, a franchise network with scores or hundreds of franchise agreements, all separately negotiated, precisely for the reasons that I put forward in my structure of opening. This is a network where franchises are offered on broadly equivalent terms to all franchisees who are mutually interdependent. And the benefit that a franchisee obtains by joining that network is the goodwill vested in the franchisor, which is also a function of the success of all the individual component parts of that business, namely the other franchisees. So it's not feasible to have a situation in which terms of this kind are likely to be the subject of bespoke negotiation.
Well, that seems to be confusing, if I may say so, two different questions. Question one, do you need, as a matter of practicality, to have a standard set of contractual terms? And one can understand why, from the franchisor's perspective, there is a need for that. But the mere fact that you need, for practical reasons, to have standard sets of terms doesn't dictate the content of the restrictive covenants, does it?
Lord, when your Lordship says for practical reasons, may I venture to submit, it depends what one means by that. In order to run a fair network, there should be standard terms across that network in order for the relations between franchisees themselves not to be soured.
But that sounds as if it's getting perilously close to saying that the reasonableness of the restriction as between the claimant and the defendant is also to be judged by reference to its reasonableness vis-a-vis a whole load of other franchisees who are not in dispute with it.
Lord, no, I'm not going that far. What I'm saying is the question of practicality
If the reality is that this court concludes, as the judge did, that these restrictions are unreasonable and go too far, then your client's going to have to rewrite its restrictions. Maybe it has to do that for all its franchisees. But the mere fact that what it uses as a standard form, because it doesn't want to distinguish between the franchisees, doesn't mean that the restriction is reasonable vis-a-vis this franchisee.
Well, Lord, if your Lordship, this is going to sound slightly impertinent, it's not intended to be, but if your Lordship's point to me turns out to be your Lordship's view in due course, then all we're looking at is this particular contract between these two parties, then there may not be a need for the franchisor to rewrite anything, because if the peculiar characteristics of this franchisee, this covenantor, are going to be said to dictate the answer to reasonable level of protection in relation to this territory, then it could be said to have no effect anywhere else. But the point, it might be right, but the point I want to say is that why, I'm going to come back to try and meet your lordship's point that you put to me a couple of times, that you find it surprising that we shouldn't be looking at the characteristics of the covenantor.
Covenantee.
Covenantor.
Yeah, sorry.
Franchisee,
Sorry,
covenantor.
franchisor, yeah.
Yes, I've tried to practice that a few times to make sure I didn't get them the wrong way around. So the covenantor's interest, I've already addressed. The reason, and we're looking at Call Quick, Dynarod, and Chips Away in those cases, the reason why a franchisor has a requirement for reasonable protection is to replace the franchisee. So
that's one of the reasons. That he has other reasons, but for sure he has other reasons. But can I just wind back a second, because what you said in answer to my question and elaborated in answer to my lord's question is that it's fundamental that the franchisor needs to treat all franchisees equally. Now, the question I want to ask you is, why so? If all franchisees were equal, then one could understand that submission. But why do you need to treat equally the franchisee who is a novice in the business and perhaps has personal characteristics unsuited to the business, with another franchisee who is experienced and established and already has a lot of goodwill in this area?
the answer brings me back to what I've already said, that when one's looking here at two people going into business, they've not gone into business to fail, they've gone into business to succeed. And that is the relationship between the franchisor and the franchisee here.
Well, that's just a freedom of contract argument. But the whole point of this area of the law is there isn't complete freedom of contract.
It's not a freedom. I didn't mean it as a freedom of contract argument. I meant that they have, if they've gone in this business to succeed, looking at the quality of covenant by looking at the personal characteristics of the covenantor is wrong in principle.
Well, I appreciate that's your submission.
Yes.
But what I'm asking you is, and we'll look at the authorities later, obviously, and you may turn out to be right on the authorities, but what I'm interested in is conceptually. Why conceptually should one treat unequal people equally?
Because of the reason for the restriction, which is, and I appreciate entirely as your lordship says, this is not the sole reason, but the one routinely relied on and routinely approved by the courts, is the need for the franchisor, having pumped money into this franchisee's territory, having promoted him, trained him, marketed him, the need to find somebody else to take over that territory who will be prepared to do so. Who will be prepared to do so in the sure and certain knowledge that there is an outgoing former incumbent who is now set up in competition.
Yeah, but that make it, in a sense, that simply proves the point my lord's putting to you, really, because the person who's incredibly successful, who's making £2 million a year in a franchise in Bristol, wherever it happens to be, is in a completely different category from somebody like Mr Bartlett, who frankly was not frankly successful. And even if he set up in competition, query whether there was any real competition from him in view of the fact that he wasn't all that successful.
Well, let me just take the phone number. He was using the franchisee's phone number in order to kickstart his new business. It's not
stopped because you had a separate clause that dealt with that issue.
Quite right. But Lord, the point is what you can't do in advance, and this is a question that we need to address from early October 2018. It is not right, and it would be contrary to principle, for this court to approve a judgment which says that the type of restriction which is appropriate must take into account some marked evaluation of the characteristics of the covenantor as to whether he might or might not provide competition in due course, because you are going to invest time, money, training and skill in that person, including his acquired knowledge of your business model and systems, which he doesn't currently have. So no franchisor could conceivably go into a franchise negotiation and agreement by making an assessment that if this particular franchisee does not succeed or chooses to leave, and it could be either, he could be moderately successful but choose to turn the signs round and work for himself if he thought he could get away with it. Or he could be reasonably unsuccessful and choose to turn the signs round because he thinks he can make more money on his own. You can't expect a franchisor to be able to have some sort of assessment at that stage of the likely competition that he is going to bring about. Because having invested in him, having invested in that franchise territory, having trained him, it can't be assumed that he will not provide competition. And the point that I made a few moments ago remains the same. A territory will not be further sold, typically, unless the incoming franchisee can be satisfied that they will get a proper start and that they will be able to compete on a level playing field. Now, what is a franchisor to do? To say, well, the last bloke we took on was actually fairly useless. We thought he was going to be fairly useless. We think he is fairly useless. He isn't set up in competition to you, and he has got, customers, and they know his number, and he knows their number, and he's going to try and get work from them. But don't worry about it. That is not, with respect, a practical way of running any form of franchise network. And just as, for example, we'll come on to look at these a bit later, the policing clauses in clause 18, just as there's authority which says it's not sufficient just to have a non-solicitation clause, you have to have a policing clause as well, because it's not practical to police non-solicitation clauses. Just so is it not practical to say that a franchisor in this particular arena is going to be able to sell to a new franchisee where there is a former incumbent set up in competition. And that is the interest that requires the protection. That is why, my lords, I have suggested, by way of submission, that the personal characteristics of the franchisee, which are front and centre to the trial judge's assessment, are not relevant because they don't address the interest of the franchisor and they don't address what that interest requires to be protected from. It's not just whether he may or may not be good or bad competition, because that can't actually be anticipated, can't be established in advance. The protection is to afford the franchisor the opportunity to replace, and that we see in every case from Colquitt onwards. That was the judgment of is on Judge Roger Cook, but sitting in the Chancellor division. So Lord, the submission I make is that the approach by this trial judge is completely unorthodox. There is nothing in the authorities which will support it. And on proper analysis of principle, it's wrong, with the very greatest respect. And I must venture to submit that your lordships will fall into error if you are seduced by it. So that's the principal point. We're looking at the wrong end of the telescope, or even possibly the wrong telescope, when we are focusing on the franchisee's personal characteristics. And Lord, what would then, if I can I'm just going to have a few seconds on the practicalities of what would be necessary. So the franchisor would have to make some sort of personal psychology score assessment of the prospective franchisee, and then pick a number for protection which it thought it could justify. And in due course, that's all going to be brought out in court as to whether it should have been 3 months, 2 months, 4 months, 5 months, 6 months, 9 months. it would, with the greatest respect, be setting up an inquiry which this court would not wish to adjudicate on and could not adjudicate on. And in any event, if you did, it still does not meet the central problem. That it's wrong in principle to assume that these parties signed up for failure. You have to assume they signed up for success. And if they signed up for success, then the franchisor has a quality, a characteristic, goodwill, which is deserving of protection. And the personal characteristics of the covenantor are then irrelevant to the process of how what that protection requires. What that protection requires is the recruitment of replacement. And that brings me back to the role of other franchisees. I'm not saying that this contract should be judged by the reference to other franchisees who are before the court. I'm not saying that. But what I am saying is that the goodwill of the franchisor derives from the success of all the franchisees in the network. And the success of all the franchisees in the network has, as a constituent element, that they will be protected from unfair and inappropriate competition. Because if the Cardiff franchise cannot be replaced, that's capable of having an impact on the franchisor's overall goodwill. So, Lord, I was going through the judgment. I'd very nearly finished that, but can I just complete that exercise? We know paragraph 205 on page 73. We know that Fredbar and Mr Bartlett set up in competition while still a franchisee. Paragraph 207 on page 74. More of the same, using the drain doctor telephone number. We've discussed that. I did mention a few moments to you ago that we would look at 292 and 293. So if we could look at those, please, page 87 for those using the bundle reference. So 292, we see reference to the covenants themselves, and when I refer to the wording of the covenants, I'm actually going to take it from the judgment rather than troubling you to go to the composite bundle. And your lordships will have looked at these. You know that, go over the page 88, you know that subparagraph 1 relates to the exclusive marketing territory and subparagraph 2 is the buffer around it. And the buffer around it, just so that your lordships have in mind what that's about, the justification for it. It's because the franchisee is not going to be, or may not be, confined to working only in the precise territory which is allotted. Hence my dipping of toe into the competition point. And again, this has to be judged at the time. There's no point in saying, well, actually, as I think this trial judge actually did, he actually said, well, he didn't actually do much work outside his territory. Well, that's actually not relevant. The relevance is the date when they entered into the contract. Paragraph 293, I've already introduced this point. It's the last sentence of that. I've already introduced this point earlier, but I told you I would point it out to you when we got there. Paragraphs 295 and 296, where Mr Strelitz took the judge to well-known franchise authorities Colquitt and Chipsaway, and I will come back to look at those, I promise. And then just by way of some additional points, the judge had evidence of Mr Bartlett that he had seen the advert for Drain Doctor. I'm just going to give you paragraph reference numbers in his witness statement, if I may. That's his 6th witness statement in the supplementary bundle.
So he had evidence that what?
That he did see the advertisement for Drain Doctor, which is the point I made earlier, that he saw it, but the finding was to rely on it. So that is his sixth witness statement at page 104 of the supplementary bundle. He had discussions with BFI qualified franchise professional. We've seen that in the judgment, and that's paragraphs 9 to 12 of his sixth witness statement. He had discussions with his NatWest business manager, paragraphs 13 to 14 of the sixth witness statement. He attended an induction day and spoke to other franchisees before he signed up.
You saw that?
Yep, paragraph 16. But this is the evidence which is sitting beneath the
But why do we need to? Because we got the judge's findings of fact. That's all we need.
Well, Lord, there are one or two points there that I did want to bring out, and I've got a list. But the first one I wanted to bring out was that he had seen the advertisement, because that was the subject of discussion.
The judge clearly found that he'd seen the advertisements, just found that he didn't rely on them. There's a whole chunk of the judgment where he deals with all that.
Yeah. But reliance is different from factual making.
No, I understand that, but I mean, the points you've just been making are all there in the judgment, as my lord says.
Now, Lord, therefore, if we move on very slightly, I'm just going to remind you of what it was that the franchisor granted to the franchisee in and about this franchise agreement. So, if I just give you the words, and I'll give you the reference where you can find it in the franchise agreement if you want to go and see it, but I don't think it matters. Exclusive marketing territory, clause 3.1, and that's at 248 of the supplemental bundle. It's a 10-year agreement, we know from the judgment. We also know, this is clause 5 of the agreement, that there were what were called initial obligations on the franchisor, which is to provide training, advise on products required to commence business, and that's clause 5 on page 250. The franchisor then had continuing obligations to provide further training, keeping the manual up to date with improvements, and to make staff available for advice to the franchisee. Clause 6, page 250-251 of the supplemental bundle. The franchisor had the obligations to promote and advertise the Drain Doctor business and to establish and maintain key account customers. Clause 11, page 252-253 of the supplemental bundle. And I've already mentioned the question of sale, which I don't think the judge does deal with in his judgment, and you'll see that at clause 16 of the franchise agreement at page 256 of the supplemental bundle in schedule 6. I think I've already given you that reference, but there it is again. There was evidence before the court from the franchisor about the need for time to recruit a replacement franchisee. Lord, the points that I've been making about that replacement activity and the need for protection while it's done is not being made up by me or in sole reliance upon authority. It was in evidence before the trial judge, and there's nothing in the judgment to show that that was rejected. And you will find that, if you wish to look at it, paragraphs 50 to 61 in the supplementary bundle, that's tab 8. And tab 11, paragraph 47 on page 100 of the supplementary bundle. So that is the same Pierre Jean, if that's right, how he pronounces his name, who is referred to in the earlier paragraph we've looked at, paragraph 106. So there was evidence before the court, which was not discredited, it's not rejected by the court, of the need for time to identify, recruit, replace, and train and install an appropriate replacement. And what is curious about the judge's judgment, with the greatest respect to him, is that one finds no reference to any of that in paragraph 305. So when one looks at what the judge has done at paragraph 305, it is, if I may say so, slightly odd, if not very odd.
I'm not quite sure I understand at the moment what you say the relevance of this factor is. I mean, it's obvious that you can't replace an outgoing franchisee overnight, particularly if no notice is given by the outgoing franchisee. And one can see the judge must have been alive to that. He goes through the process of recruiting Mr Bartlett, which wasn't an overnight activity either.
No.
So clearly some time is needed, but what's the relevance of that?
The relevance of that is that if the exercise that the judge was undertaking in paragraph 305 was to consider the reasonableness of the restriction, he would have been required, with the greatest respect to him, to consider the evidence of that need. If that's the correct exercise, I would make the submission that it's not the correct exercise for the judge to undertake. But if it's the correct exercise for the judge to undertake, he has not considered that to be judged in the balance against the factors that he's got in paragraph 305. Paragraph 305 is addressed almost exclusively to the personal characteristics of the covenantor. So I'm entitled on behalf of this appellant to make two submissions about that. One, it's wrong. I'm either right about that or I'm wrong about that, but that's what I'm submitting. But if I'm wrong about it, it still is odd that all the judge has done is to consider the characteristics, and not actually considered them in the light of the need for the restriction. Because, for example,
I'm still struggling to understand this. The judge accepted that there was an interest which merited protection because he accepted that there was goodwill. So that was a finding in your favour. So what is the finding that you say he should have made but didn't make in your favour?
It's not a finding in my favour. It's the question, having accepted that we have goodwill, it is why we have goodwill and why that goodwill requires protection. It requires protection for the purposes, primarily, but not exclusively, for recruiting and installing a replacement.
But the judge at 296 records faithfully the submission that your junior made, which is exactly the submission you were just making. As that part of the goodwill was, as he says, most obviously, the protection was required to recruit another franchisee for the same territory. And
Yes.
the judge then goes on to say at 305, notwithstanding the goodwill to be protected by the restraint.
They're
So he clearly had
for the
that
following
need
reasons.
well in mind, but notwithstanding that, it found that this wasn't reasonable.
The difficulty is, having been referred to Colquick, Dynarod and Chips Away, obviously the judge must have had in mind, and has recorded it in paragraph 296 and 7, what those cases said. The point I'm making is not that. The point I'm making is that when he looks to 305, there is no assessment by the trial judge of how those two competing issues are to be resolved. All he does in 305, with the greatest respect, is look at the characteristics of the franchisor and then decide, for reasons which, if I may say so frankly, are not clear, why that dictates the reasonableness of the clause. This is not an unfair contract terms analysis. This is not looking at factors which in an UCTA case might say that this clause was unfair or should be struck down. It's not going through factors in Schedule 1 of UCTA. That's what the judge has done. What he's done is he's looked at the covenantor's personal characteristics and he's decided that the clause against him is unfair. That's essentially what he's done. But that's not the exercise. The exercise is there is a franchisor who deserves protection. There's an acceptance as to why he deserves protection. He would then need to go on and say why it is that in this particular case that protection is too great. So is he saying this man is so completely hopeless, there is nothing to be protected against in his case? Or is he saying, my lord, please,
Could I ask you this question?
Of course.
Would you accept that on the face of the judgment, what the judge appears to be doing is to apply the passage from the judgment of Mr Justice Neuberger in Dynarod, which he quotes at 303. That seems to be the test he is applying on the face of the judgment.
Yes, but he's not when we get to 305, because if I'm right that the characteristics of the covenantor are not pertinent for this, then we don't actually need to get into this debate. If I'm wrong about that, then what is required is an evaluation. It's a wrong exercise in my respectful submission, but if we're going to get into it, it has to be an evaluation of why the protection which in principle the franchisor is entitled to does not apply in this case. And he hasn't done that. And it's got to be why it doesn't apply in this case on the 4th of October 2018. And he's not done that. So, for example, can I just isolate one hard case makes bad law point? Because this is where this judge's approach is going to lead if it's not resolved in our favour. He says it is a relevant question to the protection required, reasonably required, for the franchisor to recruit, install and replace. That if the clause is upheld, this man may lose his house. Now, with the greatest of respect, and I mean no disrespect to Mr Bartlett, and I'm not becoming involved here in a value judgment of him, of his lifestyle, or of the effect on this of his family or anything else. I'm not going to say he's the wronged party or we're the wronged party in this, in the termination of this franchise. What I am saying, and I'll say very clearly, and if I'm wrong, so be it, that whether in the event in 2020, 21, 22, if he was not allowed to compete, he might lose his house, is utterly and completely irrelevant to the question of what protection the franchisor reasonably requires. His right to protection does not change according to the effect in the event on the covenantor. Now, that's harsh, but it's entirely correct. The fact that he provided a self-assessment with his assets of the fact that he was going to have to borrow, and I think he borrowed, for recollection, half of the 35,000 initial sign-up fee. The fact that he would remain liable to repay that. The fact that he wants to earn a living somehow after the termination of his franchise in order to pay those debts. All those points are completely irrelevant to the question whether the franchisor is entitled to the protection which this judge has acknowledged it's entitled to. What he's then gone on to do is to say, I'm going to rob the franchisor of that entitlement for utterly collateral, irrelevant reasons. So, for example, let me posit this, if I may. Suppose in the month before this trial, Mr Bartlett got a win on the national lottery and was honest enough to tell the judge about it. And actually, he could perfectly well live without working in Cardiff during the period of restriction.
That's plainly a post-contractual event, whereas his financial circumstances, as known to your client at the time of contracting, stand in a different position.
Well, my lord, they don't. That's the point. Because if let's suppose we know his finance precarious. I'll use the word precarious, but I'm not making a value judgment about it. But let me just make that as an argumentative concession for the moment. parties have still gone into this relationship in order for it to be a success, if it can be. Mr Bartlett is still going to form relations with customers. We are going to promote Mr Bartlett and Fredbar at the expense of the franchisor in Cardiff for the purposes of trying to meet that mutual objective of success. We have provided him, and you'll see that in the evidence provisions that paragraphs that I've given you, we provided him with trained staff to train him, people with qualifications to train him. We provided him with the system, the model, the manual, all he needs in future to be in any way, shape or form competitive. The only relevance from the point of view of the franchisor, and the only relevance from the point of view of looking at the reasonableness of protection that the franchisor requires, is to see whether there was on the date of sign-up a contemplated prospect of Mr Bartlett and his company being put into the position, as it turns out at the franchisor's expense, of being able to be competitive. That's the question. And I do agree, Lord Justice Arnold's point about a post-contractual event, I entirely agree that, but one can't read paragraph 305 without thinking that the judge has fallen into, instinctively, that error. Because it could not conceivably have been contemplated by these parties in early October 2018 that Mr Bartlett would not be in a position and would not be put in a position by the franchisor where he was capable of providing competition. That's the question. What one doesn't do is to look at the situation in 2020 when it's all gone wrong.
But the judge doesn't do that with respect. I mean, the specific point you're making is what the judge says in 305A is, in addition, the claimant knew, that's new at the time the agreement was entered into, clearly, that Mr Bartlett was investing all his savings, would have no other source of income other than his partner's relatively small one, would be at serious risk of losing the family home should Fredbar's franchise business not succeed.
Yes.
So that the judge is making a finding as to your client's knowledge at the time the agreement was entered into. He's not making a finding about what might or might happen in 2022.
But that finding is very interesting, but it does not address the question whether, objectively, on the date of the agreement, there was a clear conclusion that this man would not be placed in the position where he would provide competition. It is plain and obvious, I would respectfully submit, that these parties went into this agreement on the basis that he would be trained, assisted, supported, marketed and promoted, precisely so that he would be in a position to provide competition were he to leave. So if one asks oneself that question, which is the question one must ask oneself if one assumes the basis of the protection which was the evidence of the claimant and which is baked into the authorities of Colquitt, Dynarod and Chipsaway.
Shall we have a look at what the authorities say?
We could, Lord, I was going to look at the authorities from Nordenfelt onwards. I'd prefer to do that unless your Lordship would prefer to do it a different way.
If you finish with the judgment, I think it would be perhaps a good idea if we kicked on with the authorities.
Well, Lord, I'm going to come back to 305 because, in a sense, we got slightly stuck on paragraphs A to D for perfectly good reason. I've got things to say about other parts of it as well. But perhaps I'll get into the law now, and then if we may come back to paragraph 305 at a later stage. So can I invite you, please, to take up your bundles? May I ask, Lord the Chancellor, whether this one is going to be...
No, the only reason, the only thing that I engaged in as self-help was to do with the actual judgment.
The judgment itself.
As far as I can tell,
has been printed reasonably well.
Let me apologise that wasn't printed for you in a way that was acceptable. I'm so sorry. But can we then go to the authorities bundle? I'm going to pick it up at tab 1. Well, I want to start right at the very beginning with Nordenfeld, because Nordenfeld is a really, really useful case. Can we go, please, to page 565? You'll find this side marked by both sides. And we've also got this quoted, although from a different case, but quoted in our Scout Knocking. Now, this is Lord Macnaghten. The true view at the present time is, I think, the public have an interest in everyone's carrying on his trade freely, so as the individual. All interference with individual liberty of action and trading and all restraints to trade themselves if there is nothing more contrary to public policy and therefore void. That is the general rule, but there are exceptions. Restraints of trade and interference with individual liberty of action may be justified by the special circumstances of a particular case. It is a sufficient justification, and indeed it's the only justification, if the restriction is reasonable that is in respect of reference to the interests of the parties concerned, and reasonable in reference to the interests of the public, so framed as guarded so as to afford adequate protection to the party in whose favour it's imposed. Lord will come on to see that's been tweaked slightly, so it now is to read, I think, from subsequent authority, no more than adequate. But I think that's probably obvious from this part of the judgment in any event. So that remains the core starting point, and although it's been tweaked, it's not really been altered over the 100 and so years that have gone by since. Could we then go, please, to tab 3 and look at Herbert Morris against Saxelby? This is another House of Lords case, this time in 1916. It's an employment case, I think it's right to say, if one is looking at how to pigeonhole these. I'm not sure we need to, but that's what it is. Now, we've quoted one of the most quoted passages from this authority in our skeleton, but it's also looked at by the respondents, and I would like to spend a few minutes looking at the speeches of Lord Atkinson and Lord Parker, if I may. Lord Atkinson first. Can we go to page 700, 700? This is in the report numbering, page 62 in our bundle number. Your Lordships will see a paragraph in the centre of that page beginning, if it be assumed, I'm sorry. Now, I said to your Lordships that there were two things we had to overcome. One, that we had something worthy of protection, and two, the level of protection required. And we get that in the 4th line of that paragraph. If the restraint affords to the person in whose favour it's imposed nothing more than the reasonable protection against something which is entitled to be protected against, then as between the parties concerned, the restraint is to be held to be reasonable in reference to their respective interests. Those are the two parts with which we are concerned. The third question about a public injurious to the public is not in issue in this case. It's not advanced by the respondents. It wasn't part of the judge's judgment. So we're only concerned with the two that form that phrase that I've just read out. If we can go over the page, please, to 701, page 63 of the bundle. Can I pick this up, please? It's still in Lord Atkinson, 1, 2, 3, 4, 5, 6 lines down. The principle is this: public
Sorry,
body.
which page?
I'm sorry, it's 701 of the report, 63 of the bundle. So your Lordship sees the principle stated by Lord Atkinson at line 6. If we then, it's only 3 lines, if you then drop down, please, to where there's a paragraph beginning these considerations.
Yeah.
These considerations in themselves differentiate, in my opinion, the case of the sale of goodwill from the case of master and servant or employee or employee. The vendor in the former case would, in the absence of some restrictive covenant, be entitled to set up in the same line of business as he sold in competition with the purchaser, though he could not solicit his own old customers. The possibility of such competition would necessarily depreciate the value of the goodwill. The covenant excluding it necessarily enhances that value, and presumably the price demanded and paid. Therefore, all those restrictions on trading are permissible, which are necessary at once to secure that the vendor shall get the highest price for what he has to sell, and that the purchaser shall get all he has paid for. Restrictions on freedom of trading are in both classes of case imposed, no doubt, with the common object of protecting property, with the resemblance between them, I think, ends there. In all cases such as this, one has to ask oneself, what are the interests of the employer that are to be protected against, and so on and so forth. So I introduced by saying this is an employer case, but so those parts of this are of we would say, much less interest. And then he goes on to say that if it's an employment case, an employer must be prepared to accept some competition from the former employee, but that's a different point. So,
Mr. Jones, before you move on, you mentioned just in the previously in relation to this case that we're not trumped here with public policy. The way I had understood these cases to work is that you may look at the interests of the covenant of the franchisor that, as you say, has assets, goodwill to protect, and what is the reasonable level of protection. But are we really right to put public policy aside? Because my understanding was that it was public policy that weighed in the other side of the balance, if you like, to look at the inherent public advantage in permitting people to earn their trade, to keep themselves, to go out to work, to put themselves out there.
Lady, may I deal with that in two ways? First of all, we start with the proposition that public policy says. I think we start with public policy, not end with it. Public policy says that freedom to work and anti-competition is a basis of public policy. But it's not absolute, and there are exceptions. The exception is when points 1 and 2 that I referred to, when the covenantee has something properly considered worthy of protection. At step 2, when there's a restriction which is no more than needed or adequate for that protection. At that point, the debate ends because public policy has then been satisfied, because the exception to public policy, the threshold for that exception has been crossed. So what your ladyship is I think, positing, possibly, is that there is then a fourth step, which you then have some sort of public policy, a second public policy overlay, where you weigh up a bunch of factors. And the answer to that is that is not what happens in restraint of trade. So if your ladyship has, for example, in mind sort of Patel and Mercer type cases, those are quite different. They're very, very different. And the later case we provided for you, I think only yesterday, Harker Sinclair, actually makes the point that the Patel and Mercer case isn't in and of itself relevant to how public policy is to be satisfied in relation to restraint of trade. So so I hope that's an answer to your ladyship's question.
I hear what you say, but I'm interested in the point. Can I think like that?
I understand. The point I was addressing, if your ladyship goes back to page 62, all that considered. It's the last passage which says, it's in the middle of that paragraph, but notwithstanding this, the restraint may still be held to be injurious to the public and therefore void. The onus in relation to that would be an onus on the defendant, not on the claimant. It wouldn't be me arguing that. It would have to be Mr Grant arguing that. And I'm not aware that he has argued that. And so far as I'm concerned, the entire trial has proceeded on the basis that this case was concerned only with the first two stages. So, lady, I hope, having gone back to that, it's absolutely clear that from authority, and I will fight it if we have to, that what I'm going to call the overlay passage, it may still be held injurious to the public and therefore void, is an issue which does not concern, it's not a threshold I have to cross, it would be a threshold the respondent has to cross. And that's never been an issue in this case. So paragraph 305 does not deal with that point. Paragraph 305 starts with the proposition and finishes with the proposition of the two principles that I've elaborated, which are taken from the central passage in that middle paragraph on page 700. So, lady, if I've not persuaded you about that, so be it, but I will try and do so before the day is out. So, if we then move on, please, to page 707. Now we're into more familiar territory because Lord Parker's speech has been quoted elsewhere, and we've quoted it from elsewhere in Scully. We've taken the quote from Scully, but it's actually this quote that came from. So if I can start at the paragraph which begins, it will be observed. It will be observed that Lord Macnaghten's in Lord Macnaghten's opinion, two conditions must be fulfilled if the restraint is to be held valid. First, it must be reasonable in the interest of the contracting parties. Secondly, it must be reasonable in the interest of the public. In the case of each condition, he lays down a test of reasonableness. To be reasonable in the interest of the parties, the restraint must afford adequate protection to the parties in whose favour it is imposed. And then he goes on to deal with the other test, which in our respectful submission is not before this court. So the next paragraph begins, and with regard to the former test, I think it's clear that what is meant is that for a restraint to be reasonable in the interest of the parties, it must afford no more than adequate protection. Those additional words, I think, are additional. We don't find those three words in Lord Macnaghten's formulation expressly, but these have become absolutely classically used. So conceived, he goes on, the test appears to me to be valid, both as regards the covenantor and the covenantee, for though in one sense, no doubt, it is contrary to the interests of the covenantor to subject himself to any restraint, still it may be for his advantage to be able so to subject himself in cases where, if he could not do so, he would lose other advantages, such as the possibility of obtaining the best terms on the sale of an existing business, or the possibility of obtaining employment or training under competent employers. May I just pause there for a moment to come off the reading of the script of that and say, here we're dealing with a franchise, and I've already spent time introducing what the franchise benefits are to the incoming franchisee, so I'm not going to repeat those, but those should be read in here because this court wasn't dealing with a franchise case. As long as the restraint to which he subjects himself is no wider than is required for the adequate protection of the person in whose favour it is created, it is in his interest to be able to bind himself for the sake of the indirect advantages he may obtain by so doing. So what I said to your lordships earlier on is we will see in these cases that the interest of the covenantor is wholly aligned with the interest of the covenantee. And here is the first passage which states that. And because your lordships are dealing with public policy, one has to be careful. That's another thing that this is saying. That if one goes down the route whereby there is an inhibition on the ability to restrain, then what one is doing is also not just preventing the franchisor in this case, or a covenantee in other cases, from seeking a restraint and imposing it. You're actually preventing the covenantor, in this case the franchisee, from benefiting himself or herself by being able to sign up into a franchise that someone else is prepared to invest time and money in because it's being protected. Let me go on with the text. It was at one time thought that in order to ascertain whether a restraint was reasonable in the interest of the covenantor, the court ought to weigh the advantages accruing to the covenantor under the contract against the disadvantages imposed on him by the restraint. But any such process has long been rejected as impractical. The court no longer considers the adequacy of the consideration in any case. If it be reasonable for a covenantee, that a covenantee should, for his own protection, ask for a restraint, it is, in my opinion, equally reasonable that the covenantor should be able to subject himself to this restraint. The test of reasonableness is the same in both cases. Lord, I respectfully submit we're starting here to see, over 100 years ago, the formation of what we respectfully submit makes the trial judge's approach in this case unorthodox. So then, if we can then please go, forgive me. Yes, can we then go please to 709? I've dealt with everything else that I wanted to deal with on that page. He's drawing, it's a slightly indented paragraph about 7 or 8 lines from the top begins, "It is quite different in the case of an employer taking such a covenant from his employee or apprentice. The goodwill of his business is, under the conditions in which we live, necessarily subject to the competition of all persons who engage in similar trade." So he's drawing a sharp distinction there between a commercial covenant and an employment covenant. It's also worth picking up a couple of references in the speech from Lord Shaw, because there's some reliance placed on this by the respondent. So can we go please to report page 713. And we're going to be looking at pages 713, 714, bundle pages 75 to 76. Can we just look at the words that have been sidelined by Lord France? When a business is sold, the vendor, who it may be has inherited it or built it up, seeks to realise this piece of property and obtains a purchaser upon a condition without which the whole transaction would be valid. He sells, he himself agreeing not to compete, and the law upholds such a bargain and declines to permit a vendor to derogate from his own grant. Now, that language isn't quite right for a franchise because the relationship is the other way round, but the principle is spot on. This is looking at a vendor-purchaser. But the idea that a vendor has a business or land to sell which has been the subject of the vendor's investment is precisely the position here when the franchisor offers to sell a franchise territory to a franchisee. That has been the subject of investment. It has been built up. So this absolutely four square doesn't support the respondent and does support us. And then the bottom passage, 2 lines from the bottom, nothing could be a more sure deterrent to commercial energy and activity than a principle that its accumulated results could not be transferred save under conditions which would make its buyer insecure. Now, can I just ask you to read that passage, and instead of having a buyer-vendor-purchaser relationship, we have a franchisor-franchisee relationship. Nothing could be more sure deterrent to commercial energy and activity than a principle that its accumulated results could be leased, that's the lease provision under Dynarod, save under conditions which would make its buyer, so the franchisor, insecure. And what the trial judge's judgment has done is precisely that. He is saying that the franchisor is to be required, in the case of Mr Bartlett, to carry out all the investment to build the brand and then support Mr Bartlett when he comes into the franchise territory, but only to do so at its own risk of insecurity. So we would respectfully say that is very clearly in our favour. If we go over the page to page 76, 714 of the report, we see the second passage, which my friends rely on. In the case of restraints upon the opportunity to a workman to earn his livelihood, a different set of considerations come into play. Well, that is all about a workman earning his livelihood. Mr Bartlett did not sign up to an agreement where he was to be a workman earning his livelihood. He signed up to an agreement where he was going to be a businessman, which he no doubt hoped was going to make him a lot of money and give him capital value. That's what he signed up for. So our case has nothing whatever to do with a workman being prevented from earning his livelihood. If Mr Bartlett had wished to retain that status, he could have had the benefit of that part of Lord Shaw's speech, as it were, 100 years after it was made. What he chose to do was to sign up to a business described by Mr Justice Neuberger as symbiotic, in order that he may benefit from it. And he then gave up the status, voluntarily, of a workman going about earning his livelihood. Can we pick up a different point, please, now, and go to Guildford Motor Company, which is tab 4. We're now moving forward swiftly to 1933. Now, this is a case about a restrictive in the contract of the managing director of a company. And while a senior person, it is expressed as an employment case, and your lordships will see that on the first page, page 935 of the report, page 81 of the bundle. So he was employed as managing director, which we know is an employment status, not a simple director status. And it's clearly expressed in the head note as being an employment case. That is entirely supported by what follows in the judgments. The passage I want to take you to, please, is page 967. Page 113 of the bundle. This makes clear, in my respectful submission, albeit in a different context, that the enforceability or validity of the covenant is to be determined at the date it's entered into. I don't think the lordships need any support in relation to that, but lest you do.
It's in dispute, is it?
I don't know, I hope not, but it's about 10 lines from the bottom, a passage beginning Farwell J. There's just 7 or 8 lines there that make that point. I'm not going to focus on it. I've got, I think, bigger fish to fry today.
So which passage are you referring us to?
9, 12, 13. It's 15 lines up from the bottom. I'm sorry, it's one huge paragraph, so I can't
It's just
identify
by
it.
the second hole punch, isn't it?
Yes, just above the second
Question
whole
has to be
Question whether the
determined
covenant
at
is
the date of the
valid.
covenant.
Is a question which has to be determined as at the date of the covenant being entered into.
Yes.
Yeah.
Simple enough point, but I did say to your lordships that there's an authority of antiquity for that, and indeed there is. So then I think we need to look at Esso Petroleum and Harper's Garage. So we'll find that in your tab 6. We in fact quoted it at paragraph 27 of our skeleton. But the passage in the report it is at page 323 of the report. It's a well-known passage and has relevance to this case because it's looking at restriction and its nature. And is entirely reflective of what we have already seen, that if the restriction is reasonable to protect the covenant. 323, 181 of the bundle pages. So if we start this at line 4, it's important that the court, in weighing the question of reasonableness, should give full weight to commercial practices and to the generality of contracts made freely by parties bargaining on equal terms. I'll come back to that point if I may in a minute. Undue interference, though imposed on the ground of promoting free trade, may in the result hamper and restrict the honest trader, or on a wider view injure trade more than it helps it. If a man wishes to tie himself for his own good commercial reasons to a particular supplier or customer, it may be no kindness to him to subject his contract to the arbitrary rule that the courts have always reserved to him a right to go back on his bargain if the court thinks fit, for such a reservation prevents the honest man from getting full value from the tie, which he intends in spite of any reservation imposed by the courts to honour. So, pausing there for a moment if I may, that reflects something that we have just seen in the earlier 2 cases we've looked at, which is that this is a symbiotic relationship in which, if the interests of the covenantor require protection, then it is the same interests, it's a reflective interest in the, I'm sorry, I've done that the wrong way round, having promised myself I wouldn't do. If the interests of the covenantee, the franchisor, requires protection, then it's the same reflective interest which allows the covenantor to sign up to it, and for this court not to interfere with that bargain. And then a few lines further down, where there are no circumstances of oppression, the court should tread warily in substituting its own views for those of current commerce generally and the contracting parties in particular. So this is obviously not a franchising case, it's a very well-known different type of case, it's all about petrol ties. And I did say I'd come back to parties on bargaining on equal terms. In my respectful submission, what this is not saying is that someone can't tie himself in the way the rest of the passage goes on to, unless he's in equal bargaining terms, because that cannot be in the case of the sort of relationship we're talking about cannot be the correct answer. The correct answer for us is that we would accept that a franchisee is not in a position to bargain, but the franchisee is in a position to sign up or not sign up. And once they do sign up for the package of benefits and rights that go with it, along with the burdens that go with it. And that is precisely reflective of what we've seen in all the cases so far. Not reflected in Nordenfeld, but in all the subsequent ones, that the relationship between the covenantor and the covenantee is such that if the covenantee's interest needs to be protected, that is the equivalent of the covenantor's interest. So could we then move on, please, very quickly, just to mention it, to a case called Schroeder and Macaulay. I suspect from those with a chancery background, a case that's been looked at fairly frequently. But it's
particularly by people in the entertainment field, yes.
Yes, indeed. Lord Justice Arnold, I had just that in mind. And it was the forerunner of a number of cases from a number of quite well-known artists. It's a different kind of case. Again, because we're looking at different kinds of restraints in different kinds of areas, there's no necessary uniformity of approach. And all I really wanted to say is that the House of Lords put the equal bargaining powers into context and said that there were circumstances where a take it or leave it contract might be set aside, but the answer to that we provided when discussing SO, and therefore, although I quite understand Macaulay says what it says, it's not a case which actually deals with what we're talking about here. So that's in a sense a different line of restraint of trade jurisprudence. Can I then very quickly, unless I'm moving you too quickly away from that, go please to tab 9 and a case called Bridge and Deacons. This is a Privy Council case from 1984. Again, it's a different type of relationship. It's a partnership relationship. And we can note that Lord Fraser picked up the classic statements we've already seen. So if we go please to page 713, bundle page 227. There's reference to Nordenfeld, reference to Herbert Morris and Saxel. And I just want to pick up two passages, please, worthy of note over the page 714 of the report, 228 of the bundle. This has been sidelined by the respondents, and it's a passage marked by them where there is a reference to the position of the partner of the firm. And that is in the passage, one single two-sentence paragraph at letter G. I've used the word partner there as appellant, but that was his status. That is in reality treating a partnership restriction as if it were employment and deciding whether the managing director should have the same restrictions as a junior accounts clerk. Here, the franchisee's position in the network was the same as other franchisees. He would be granted full access to an established trading method from day one and trained to use it, and no doubt wish to be, as I've said repeatedly, a successful and established and independent business. The second passage I want to look at is on page 718 of the report, page 232 of the bundle. And that is the passage which is halfway between the hole punches, and it begins with its own paragraph: the adequacy of the consideration and the reasonableness of the contract as between the parties must be judged in 1974. The only reason I mention that is it goes to the date of the exercise. I think in the sense, if you were to read that, thinking that the adequacy of consideration is a relevant issue for conventional restraint of trade, I think one would find that was not accepted orthodox, but the timing point certainly helped. So can we now look, please, to Allied Dunbar and Weisinger? That's tab 10. This is a judgment of Mr Justice Millett in 1988. And could we look, please, at page 239 of the bundle? I'm looking at the bundle numbers only. I'm not sure I can find the page number for the report. 239. If we look at paragraph 22, which is near the foot of the left-hand column, we see that Mr Justice Millett, as he then was, reiterated the classic formulation of the test we've already seen. And if I can ask you, I won't read it out because it'll take longer, but if I could ask you just to read the entirety of paragraph 22 to the top of the next page as well, I'd be grateful. Unless I'm moving on too quickly, if everyone's reached the end of paragraph 22, may I invite you to go over leaf page 240. I want to bring your attention, please, to a passage at the top of the right-hand column.
Paragraph 30.
So it begins, I'm going to point the passages out to you because I don't need to read all of it. Finally, it was submitted that clause 9 was invalid because the additional restraint imposed on the defendant by the choice of covenant was out of all proportion to the additional benefit obtained thereby by the plaintiffs. If we drop down four lines or 5 lines, so this, it was submitted, might seem reasonable from the point of view of the plaintiffs, but it was certainly not reasonable from the point of view of the defendant. The need, well established by the authorities, to show that the covenant is reasonable from the point of view of both parties introduces, it was said, the now fashionable concept of proportionality. And in my judgment, that is a novel and dangerous doctrine. It's certainly novel, or perhaps more accurately, a revival in modern dress, an obsolete and discredited theory. There is no trace of it in the modern cases, in which it is assumed that in order to show that the covenant is reasonable as between the parties, it is sufficient to show that it is no greater than is reasonably required to protect the legitimate interests of the covenantee. And he quotes then Lord Morris. And that goes back to a point that I made this morning, and I said I would hope to make it good, and I believe that we are making that point good from the cases that we are taking you to. So it reflects the point I've already made, that once we've decided that it's in the interests of the covenantor, and it's no more a protection than they demand, than they require, then the interests of the covenantee, I should have said first time around, then the interests of the covenantor are aligned with it. Therefore, it must follow from that the approach taken by the judge was with respect to him wrong, because none of the issues that he's put in paragraph 305 talking about what the...
Why does it follow? Because the point that Mr Justice Millett was making, as one can see from paragraph 32, is you can't balance the interests of the covenantee, which require protection, with restraint imposed on the defendant. So hence no proportionality inquiry. That's perfectly clear. But your submission is that it follows from that you have to treat all covenantors, all franchisees in the present case, equally, even if they are unequal. Why does that logically follow?
Because they are not going to be equal, they're not going to be unequal, using your lordship's words, once they have been trained, once they have been given access to the manual, the model, the system, and have had the benefit of the marketing. So there's another case we're going to come on to say that because they may not be hugely effective on day one, doesn't mean that you look at the restraint and the effectiveness on day one. You have to look at the entire contract. That's also orthodox and logical. So while the personal characteristics of different franchisees may be different as individuals, they may have psychological differences, mental health differences, they may have educational differences, they may have all sorts of differences. As a franchisee, they are going to be trained and placed in a position where if they leave, they can compete and therefore damage the franchisor's goodwill. That's the point. It's the point that the individual characteristics which have been addressed by this court might or might not be apt for some sort of actor balancing exercise, but are not apt for a restraint of trade which is conventionally imposed if it is proper and no more than adequate to protect the potential loss of goodwill that could be inflicted on the franchisor. And that's the point. That's the reason why the alleged inequality, whether it's inequality of bargaining power or inequality of money or inequality of intellect, if I can call it that for shorthand, so it doesn't matter. And unless the judge was going to be saying, which he has not said, that this man was obviously so hopeless that he was never going to provide any competition at all. He's not said that. And if one can put the question forensically, what is the relevance of him putting his home at risk in order to become a businessman as to whether or not he could or could not in due course provide competition? It has no relevance to that question. That may sound harsh, but it's with respect, I respectfully submit the correct answer. So can we then move on as quickly as I may please to Watson and Prager, which is your tab 12. And this makes a very simple point, which I think your lordships are not going to want any assistance with because we've already transgressed it. We've already dealt with it. The simple point here is that whether a covenant is reasonable is judged by its terms and not how it is performed. And you'll see that in the head note. And the key text for that purpose is at page 749 of the report. That's using the report pages. 749 letter F. Lord, I don't take it that that's an issue of debate, certainly between. I don't think I've been challenged on that, so I'm going to assume it's correct at the moment. But there's the passage for your lordships to quote if you want to come back to it. Can I now then come to call quick? So we're moving now into franchising territory in 1995. We're going to look at the three cases that we've looked at in principle already. So call quick, Dynawad, and Chips Away. So call quick first, tab 14. So the starting point here, we can pick it up on the very first page, bundle 285. This was a 2-year restriction, not to engage directly or indirectly, whether as director, shareholder, partner, proprietor, employee, officer, agent, or otherwise, in any business competitive with the business or the business of the franchisor within a 10-mile radius of the location, or of any premises of the franchisee, or any franchisee of the franchisor. So could we go over the page, please, to bundle 286? This is still in the holding section of the head note, but it's a useful summary. So, held, granting the interlocutory injunction sought an amendment. So, restriction upon competition was appropriate having regard to the retransfer of goodwill taking place upon termination of the franchise agreement. It did not matter that there was no specified sum attached to the retransfer of goodwill, it being part of a wider commercial deal. Can you then please drop down to holding number 4? A non-solicitation clause on its own would not be adequate to the plaintiff, as it would be virtually impossible to police. That is a point I mentioned to your lordships in an argument this morning. I promised you a reference to it. There it is. Holding 5, 2 years was not excessive in a goodwill covenant and was not an unreasonable period to allow a new franchisee a clear run. Now, the reference to clear run is interesting because, of course, one focuses on the proposition of getting someone identified, recruited and installed, but their interest is going to be ensuring that they are going to take the franchise territory where they are not subject to what they would consider to be unfair competition from the previous incumbent. So a clear run, I think, is a very helpful expression here, because that encompasses everything from getting recruited through training, through getting started and getting known and established. May I then please take you to page 290. I'm so sorry, 289. Can we start one page earlier? 289 of the bundle. If anyone's making a note of the page report reference, is 118. So may I start, please, looking at the passage that we've sidelined. So just one sentence below where we've started. The authorities have, down the greater part of this century, drawn a clear distinction between covenants between master and servant and covenants affecting goodwill. Those include, of course, partnership covenants, but particularly vendor and purchaser covenants. In the case of master and servant covenants, mere competition cannot be restrained. In the case of vendor or purchaser or goodwill covenants, competition can be restrained, if only for this reason: that competition by somebody who has dealt with goodwill, as it were, in favour of the other contracting party would necessarily amount to a derogation from what otherwise he would have contractually performed. Franchises do not fit snugly into either scenario. In what might be described as the formative period of franchises in the 1960s, some of the earlier authorities suggest that the courts might have viewed them as master-servant covenants. But it seems to me that certainly as franchises have grown in sophistication, that is no longer right. He then makes a reference to prontoprint. He then quotes from Lord Shaw in Morris and Saxelby, and I've already taken you to that quote in the original text, so I'm not going to ask you to read it again. If you would then please go over the page with me to page 290. There's a reference to Mr. Justice Whitford commenting on that passage, that's to say Lord Shaw. It's of course apparent that the circumstances in this case differ from those of a sale of a piece of property, but they are, in my view, rather closer to that situation than the situation as between employer and employee. The plaintiffs are in a franchising business. They want to get franchises and have franchises up and down the country. For that purpose, they want to ensure that they're in a position to prevent competition against franchisees whom they might appoint by persons who in fact build up their knowledge and interest as franchisees. I gratefully adopt what Mr. Justice Whitford said. In this case, I think the position is perhaps even clearer because of the obligation to hand back the goodwill at the end of the franchise, though I'm inclined to think that obligation would be implied in any event. One way of looking at a franchising agreement is that it is a form of lease of goodwill for a term of years, with an obligation on the tenant, as it were, to retransfer the subject matter of the lease at the end of the lease in whatever state it is. So to that extent, there is an obligation to transfer goodwill in a particular form, and so on and so forth. So I don't need to spend further time on that, but except perhaps to pick up just the last 3 or 4 lines of the part that's sidelined. So there's a reference to Bridge and Deacons, which we've already already looked at, and then this passage, I think the proper way of looking at it, this is all part of a wider commercial deal in which profits and losses pass between both parties. So it's not really necessary to try and identify one particular consideration which attaches the transfer of goods as such. That's not quite apt for what we're talking about here, but the reference to it being part of a wider transaction, commercial transaction is. May I then pass to Scully, which is tab 16 of your file, if you're looking at it electronically, and if you've broken it up into two bundles, it's probably in the second bundle. So tab 16. Now we've referred to this at paragraph 21 of our skeleton because that provided an up-to-date recitation of Lord Norton in Nordenfeld and Lord Parker in Herbert Morris. We've already looked at those, so perhaps in order to save time, I won't actually take you through that passage, but we've sidelined it in page 344 of the bundle. But I think you've seen all the text there, so that brings it up to date. When we say it's been orthodox for a long while, that brings it up to date to 1998. Can we then move on to Dynarod? And Dynarod is your tab 17, page 355 in the bundle reference numbers. This, as you all know, is Mr. Justice Neuberger as he then was in 1999. This was a franchise case. There was a restriction of 1 year against any involvement in any business in competition or conflict with the franchisor within the franchise territory. May we start with the head note, please? And we're going to look at the very first paragraph of that. I'm going to pick up the last 6 lines or so, beginning the covenant. The covenant provided that for 1 year following termination, the defendant should not have any involvement in any business in competition or conflict with the plaintiff's business within the former franchise territory. And we know that there was a claim for an interlocutory injunction. If we can look at the holding, number 2, a franchise agreement could best be seen as a lease of the franchisor's goodwill, or franchisor as we'd say now, and was close to the vendor-purchaser type of case than employer-employee. Any covenant in it needed to satisfy a far less stringent test of reasonableness than was required in an employer-employee case. Over the page, can we go please to holding 4? A mere solicitation provision would be difficult to police. That's a point we've seen earlier a few moments ago, and it's repeated here in this case, and would not address the plaintiff's primary concern, which was to find and protect a new franchisee in the area. That was threatened by the defendants, who had been trained by the plaintiff, had long been associated with the plaintiff's name and goodwill, familiar with the local customer base, price structures, marketing techniques and the like, and would be able to undercut any new franchisee. Holding 5, considering the width of the restrictions on the one hand and the potential for the franchisee to take unfair advantage of the plaintiff's investment on the other hand, the covenant was a reasonable one. And I've been banging that drum about investment and protection during the course of the morning. I don't need to repeat it. So if we go then, that's the head note, if we go to the principal text please, could we go to bundle page 359, which is report page 152. If we look at the foot of that page where we've put a sideline in and there's a shorter and fatter sideline from Learned Friends, the covenant itself must be judged in the context of the deed under which it forms part and the factual matrix in which it is to be found. Then there's a reference, which we've seen in the head note, doesn't fall happily within either of the two categories where restrictive covenants of this sort are normally thought to be found. Can we then go over the page? Perhaps we could pick it up at the very last line of 359, please. Sorry. Similar observations are made by Lord Justice Lawton in the same page, 43, that as franchising has developed, the court's approach towards a franchising agreement has become perhaps somewhat more refined. Could we then drop down, please? Because all I'm missing out is pronto print, which you've already seen a reference to, Mr. Justice Whitford, and His Honour Judge Roger Cook sitting as a deputy in Colquitt, and we've seen that. So can we drop to the passage at the bottom, which begins in my judgment, and just go 3 lines further below that with this sentence. I would agree, essentially for the reasons given by Whitford J and Judge Cook, that franchise agreement is closer to a vendor and purchase agreement. I consider that the lease analogy of Judge Cook has its attractions. If one goes through the terms of the agreement in the present case, it seems to me that the point is rather reinforced. The franchisor, that's the plaintiff, and the franchisee, that's essentially Mr Reeve, each have a business. They're symbiotic businesses, and the goodwill provision to which I've made reference in clause 5.3, while it emphasises the goodwill is ultimately that of Dynarod, it nonetheless indicates that the franchisee, Mr Reeves, have the benefit of the goodwill as long as he's the franchisee. Similarly, as Mr Tritton says, provisions in clause 20 relating to the sale of the business by the franchisee, the business defined as being the franchisee's business, make this far more similar to a vendor and purchaser case, because the franchisee does have a business and an employer-employee relationship where the employee has no business. So, and we've already seen that this is a business capable of being sold by the franchisee with capital benefit to him. Can I then drop halfway down that same page, so we're now on page 361. There's a passage with a paragraph indented beginning in the present case. May I read that, please? In the present case, the covenant has various ingredients. The first question is, although the covenant must be judged as a whole, I think it is useful to approach its various ingredients separately. The first is the period of 12 months. Is that reasonable? I find it difficult to see it could seriously be argued that it's not. Again, each case has to be judged on its own merits, but I notice that in Colquitt, Judge Cook said that he had little hesitation in holding 2 years as a reasonable period. In Prondepend, Mr Justice Whitford held 3 years was a reasonable period. They both concern franchisees. Next paragraph, bearing in mind the nature of this franchise agreement, the nature of the training which the franchisee, Mr Reeve, obtained, and the nature of the protection which the plaintiff seeks, to which I shall return shortly, and in the light of what is said, I have no hesitation in saying that 1 year is a reasonable period. We then pick up the next paragraph. The second ingredient to which I shall return is the area. The area is the territory. There is therefore, to use the elegant expression of Lord Justice Slade, a functioning correspondence between the area of restriction under the covenant and the area within which the licensee, in this case the franchisee, can operate. It will be recalled that the franchisee's areas of operation, as long as the franchise survives, is the territory. Next sentence, the nature of the business carried on is not that of a shop, where one might argue that there is good reason, or maybe good reason to think that as one gets further away from the shop, whatever the area of the territory, the amount of business and goodwill will die down and reduce quite considerably, as was the case, it would appear, or could have been the case in Colquitt. Although obviously the defendants need premises of some sort, this is a case where by definition Mr Reeve had to go out to visit properties and people would not come to him. So again, reflections of this case. Can we go over now to 362? And all this has been sidelined, but I'm not going to bring your attention to all of it by any means. I'm just going to pick out the best bits. Could we go to the paragraph beginning again? That's the first indented paragraph, please. I've had the opportunity to consider the areas in the other cases in which reference has been made. Certainly in office overload, the area was both that equivalent to the territory in the present case and appears to be an area fairly similar in actual size to that covered by the covenant in the present case. In Colquitt, it was 10 miles, so on and so forth. The next paragraph, the real argument appears to centre around the fact that the covenant seeks to prevent the defendants engaging in any business in conflict with that of the plaintiff. The defendant's case in a nutshell is that it should be sufficient for the plaintiffs and is enough in terms of reasonableness for the plaintiffs to be protected in effect by a non-solicitation provision. Now then, can we go down to the next paragraph beginning, it does appear to me. It does appear to me that when one considers the nature of the franchise business, when one considers the nature of the business between the plaintiffs and the defendants, including the training which the plaintiff gave, including the know-how which they gave to Mr Reeve in the form of the manual, including the use of the name which they gave to him, the name Dynarod obviously being a well-known name with a substantial amount of goodwill, when one considers the experience which he was thereby able to build up in terms of not merely knowing the business but knowing the area, what the plaintiffs are seeking would seem on the face of it to be reasonable. Over the page, please. This may be my last shout before the short adjournment, but let's see how we go. Page 363. 2 passages to bring your attention to. The first paragraph on the 4th line down. As Mr Tritton says, it is not from other drain and cleaning businesses that an incoming franchisee needs protection, or, I add, could conceivably be entitled to protection. It is from the plaintiff's own franchisees. Incoming franchisee is entitled to protection, provided that that protection is reasonable. In this case, the protection sought and contractually agreed to 1 year, and it's only within the area. It is obvious that the plaintiff will be likely, and one will have to judge as the date agreement, to have far greater difficulty in attracting a new franchisee if the ex-franchisee is known as a Dynarod franchisee with all the Dynarod experience and contacts and is operating in the territory. An ex-franchisee has the benefit of considerable investment by the plaintiff, which puts the ex-franchisee in a better position than others. Providing that it is reasonable in terms of the public interest and not unfair to the ex-franchisee in terms of time or area, the plaintiff is entitled, in my judgment, to ensure that his investment is protected by ensuring unfair advantage is not taken by an ex-franchisee by, for example, prematurely determining the franchise agreement and setting out on his own. So the 2 pages of that judgment, which we've sidelined, and I've just walked you through the key passages from, provide, we respectfully submit, a classic statement of the law, and has been so for about the last 25 years, and there is nothing as yet which would undermine the approach they're taking. Lord, I'm conscious of time, but if I could just ask you to look at chips away with me before the short adjournment, that would help me make progress after the short adjournment. So that's tab 18. So we've moved on slightly now to 2009. We're in the Court of Appeal. It is a franchising case, and the judgment we will be looking at is the judgment of Lord Justice Dyson, as he then was. So can we go please to bundle page 373. And we've got 2 passages sidelined, and I just want to bring your attention to parts of them. On paragraph 20, the last 4 lines, please. Both the claimant and the new franchisee would have an interest in the success of the new franchise business. One way of promoting that business would be to limit competition of a previous franchisee, and that is the obvious purpose of clause 23.1. So, Lord, can I just very quickly say, I've made some comments this morning which may have been slightly misunderstood about the interests of other franchisees, not just these 2 parties. But while I hope I made clear the value of that submission and the width of that submission, I think I'm fair to say that it has support from the authorities, here the Court of Appeal. Could we then move please to paragraph 22? The fundamental objection to the judge's interpretation that it does not achieve a sensible commercial purpose. As Mr Evans-Tovey points out, during the term of franchise, goodwill is built up in the territory with the use of the franchisor's name and branding. Such goodwill is a potentially valuable asset in the hands of the franchisee, so long as he continues to trade in the franchise territory and in the hands of a franchise or at the termination of the franchise agreement. A franchisor's interest in that goodwill is vulnerable to competition from a former franchisee who has knowledge of the area and experience of dealing with particular groups of customers. The commercial purpose of post-termination covenant against competition is to prevent the franchisee for a period of time from continuing and competing in his former territory in the same line of business, so as to enable the franchisor to exploit the goodwill that he's built up during the term, most obviously by recruiting another franchisee for the same area. Now, it's right, and your lordship will see, that the respondents have sidelined 1 small passage in the middle of that paragraph, alongside ours. A franchisor's interest in that goodwill is vulnerable to competition from a former franchisee whose knowledge of the area and experience of dealing with a particular group of customers. The point here is, what subsequently has happened can't be any relevance to looking at the value of this covenant in October 2018. So I'm not sure, it seems to me, on the face of it, why the passage that the learned friends have looked at is of any particular relevance, because if we look forward, then we will, it's entirely proper to assume that there will have been some building up of franchisee goodwill, because that is what the franchisor has invested in. Lord, I'm not sure if my watch is entirely in line with the court clock, which I'm afraid I can't see, but there's only one other passage in Call Quick.
That's paragraph 24, is it?
Yeah, 24, page 375, and really it's all of that. So if I read it out, that may take longer than if I invite your lordships just to read it. Thank you. Thank you very much indeed, Lord. Unless you are anxious to ask me anything before we break,
No.
that's a very convenient place for me.
Say 2 o'clock then, please.
Thank you.
Cool, well, it's